On January 27, 2025, defendant Christy Cohen was charged in the Greenwood County District Court in Kansas with multiple offenses, including driving under the influence, possession of a firearm while under the influence, operating a vehicle without a required ignition interlock device, driving without insurance, driving with a suspended license, transporting an open container, and operating a vehicle with unlawful window tint. These charges arose from a traffic stop initiated by Deputy Blake Pfizer at approximately 9:20 p.m. on January 22, 2025, based on suspected illegal window tint. On June 16, 2025, Ms. Cohen's attorney, Jorge De Hoyos, filed a motion to suppress, arguing that the traffic stop lacked reasonable suspicion and that all evidence obtained as a result should be excluded. The state subsequently filed an amended complaint on June 24, 2025, elevating the DUI charge to a felony due to Ms. Cohen's prior convictions. That same day, Magistrate Judge Phyllis Webster held a suppression hearing and later issued an order on June 30th denying the motion. Because the amended complaint converted the case into a felony prosecution, Ms. Cohen was entitled to renewed consideration of her suppression arguments before a district judge with felony jurisdiction. The second suppression hearing was conducted via Zoom on October 16, 2025, before Judge Charles Hart. Mr. De Hoyos appeared on behalf of Ms. Cohen, while County Attorney Jill Gillette represented the state. Our footage begins during Ms. Gillette's direct examination of Deputy Pfizer.
And were you able to see into Ms. Cohen's vehicle?
No.
Now, I know we had gone over this before, so when she went in front of you, what, if anything, can you describe to us, did the interior look like?
I can't tell you what the interior looked like. It was too dark.
And if someone has correct window tint, are you able to see how many people are in the vehicle?
Yes.
Are you able to kind of tell what the interior of the vehicle looks like?
Somewhat, yes.
Have you been using this technique for a while?
Yes.
And when you stopped this car, did you eventually test the window tint?
Yes.
What was the window tint reading of the vehicle when you were able to test it?
It was 11% window tint.
What is the legal percent in the state of Kansas?
35%.
Do you explain every time you go through a case all of your experience or how you use specific testing?
No.
And so is there anywhere in your report you explain how you use your experience and this technique of checking windows?
Not that I believe.
I will pass this witness to the defense.
Cross-examination, Mr. De Hoyos.
Judge, thank you, sir. Deputy Fisher, I want to make sure I understand the way in which you determined the windows were too dark. How long did you have to observe the vehicle that you pull over?
I don't know an approximate time frame. I mean, she was driving by at highway speeds.
Okay, and that highway, that's US 54 or 54-400, is that what that is?
400.
Forgive me, 400. Is 70 there? 75?
65.
65, okay. Middle of the night, right?
Correct.
And you say that the technique you employed was you had you flash your high beams to see if you could see through the windows, is that right?
I don't flash them, I sit with them on.
Okay, so you sit with them on and help me understand what happens after that.
As the vehicle drives by, I make my observations.
Okay. Yeah, I mean, is this a lawfully approved technique? I mean, is there a sheriff's or a county association or any kind of police association that approves of this technique?
Not that I know of. I mean, it's reasonable suspicion. She drove by, saw that the window tint appeared to be too dark, so I had reasonable suspicion to believe that the window tint was too dark, so I initiated the traffic stop.
So hear me out, Deputy Fisher. I appreciate that. When it comes to the lawful definition of reasonable suspicion, all that, I'm not worried about that. I'm trying to understand the facts. And the fact is, you use a technique that has not been supported by any lawful community or law community that you're aware of.
No, we all use it.
As it stands right now, you don't have the experience to be able to say that at a passing glance what percent the window tint is.
I can't tell an exact percentage, no. And I don't think anybody would be able to tell an exact percentage, but I know that if a vehicle is driving by and I can't see into the vehicle, it's reasonable to believe that it is too dark.
Okay, so if somebody drove past you while they're holding a blanket against the window, does that mean their window tint is too dark?
No.
Okay, but that would still create the same effect that you not being able to see through the windows and then pulling them over because the window tint is too dark, even though that wouldn't be true, right?
I would disagree with that.
Okay, which part?
Well, if the window tint was not too dark and they drove by and they were holding a blanket up, I would be able to see that they were holding something up. As she drove by, I wasn't able to see her or any other person in the vehicle, indicating that the window tint itself was too dark.
And are there any outside circumstances that can affect your judgment as to the lightness or darkness of the window tints as they fly by at 65 miles an hour?
As in,
oh, I don't know. In a storm, would you make the same call? Would you make the same pullover and same arrest?
I mean, it could alter some, I guess, but no, not really.
So at the time in which you observed the defendant's vehicle, was it by itself or was there any other vehicle within its proximity?
It was by itself.
So if the video of you observing that, I think it was a Chevy Sonic, demonstrates that it was right next to and alongside an 18-wheeler that was all black and that you observed it with the all black background, that would not be consistent with your memory and the way you would do this technique. Is that correct?
I mean, from what I can recall, like I said, I haven't been through the video. I haven't been through the report. From what I can recall, what I saw was her. I wasn't paying attention to any other vehicle. And it was the front passenger side window that I was paying attention to. She was closest to me. We were in a 4-lane highway. She was heading eastbound. She was the closest vehicle to me. So I was looking at that window specifically.
Okay. Well, I appreciate that. I have a body or a dash cam video. So, Your Honor, I'm going to move to admit Defendant's Exhibit A. This is the dash cam video from Officer Fisher's vehicle that demonstrates what he would have seen as the vehicle the defendant was driving passed him by at 65 miles an hour on US 400.
Any objection by the state? Ms. Gillette.
No, Your Honor.
The exhibit is admitted into evidence and the court will view the same.
Can you see it okay, Judge?
Yes.
Judge, if I may resume cross-examination.
Yes, please resume cross-examination of the Deputy Fisher.
Before we continue, I want to take a moment to thank the sponsor of today's episode, Surfshark. If you've ever used public Wi-Fi at a hotel, airport, or coffee shop, you've probably had that uneasy realization that you have no idea who else is on the same network. You don't know who might be monitoring traffic, intercepting data, or scraping information from connected devices. In 2025, that's not paranoia, it's just reality. Surfshark is a VPN built for people who take online privacy seriously. When you use Surfshark, all of your internet activity is encrypted, including your banking information, emails, passwords, and search history. Everything travels through a secure, private tunnel that blocks hackers, trackers, data brokers, and other third parties from accessing your information. One of the biggest advantages of Surfshark is that a single subscription covers all of your devices at the same time. There are no device limits. On top of that, Surfshark operates under a strict no logs policy, meaning they don't collect or store your browsing activity in the first place, which is exactly how a privacy-focused VPN should work. Surfshark also offers servers in more than 100 locations worldwide, making it an excellent option for travelers or anyone who wants reliable protection wherever they are. Right now, Surfshark is offering members of the ATC community 4 additional months of service when you visit surfshark.com/court or use code COURT at checkout. If protecting your personal information matters to you and you want a VPN that works across every device you own, this is a great time to take advantage of that offer. Thanks again to Surfshark for sponsoring today's episode.
Just real quick here, Deputy, that's a true and accurate copy of the video that would have been observed from your dash cam that night. Is that right?
Correct.
Okay. And there was at least another vehicle on the roadway, that being the semi that was behind the defendant's vehicle. Is that right?
Yes.
Okay. And do you agree that it's a little different than the testimony that there was another vehicle with it? There was another vehicle with it, right?
Yes, yes.
Okay. That's all I got for you, Deputy. I appreciate that.
Any redirect, Ms. Gillette?
Yes, Your Honor. Deputy, he's asked you lots of questions about what was behind the vehicle, but you said you were concentrated on the front window and inside. Does it matter what's behind the vehicle?
No.
And your testimony was that you're focused on the window. Are you focused on being able to see what's in the vehicle versus behind the vehicle?
Yes.
Now, I kind of alluded to this before. I get to spend a lot more time with deputies and talk to them. I've even done ride-alongs. Based on your experience, can you tell when a vehicle is approaching if it's faster or slower than what should be normally the speed of the vehicle?
Yes.
How can you tell?
Based on my training and experience, I've been doing this for long enough to know that the way the vehicle is oncoming towards me, I can kind of adjust the speed in my head and kind of see how fast it's going, and then I affirm that with my radar.
You said all of us do this test. What do you mean by all of us?
Like deputies and officers in general, we use the same practices.
How often would you say you do this?
Every night that I work.
Judge, I'm going to object to the relevance of these questions. If the strategy is inappropriate in the beginning, it doesn't matter if he does it 1,000 times a day.
Now,
Objection sustained.
I'm getting to my point, Judge, because experience, based on the experience and totality of the circumstances, is what he needs for only reasonable suspicion. He doesn't have to have probable cause. And he's already said he could reasonably infer that her window tint was too dark. And we're getting to his experience here. Deputy, are you provided with a tool to measure window tint?
I am.
Are you able to use that while a vehicle is in motion?
I am not.
So if you have a reasonable inference that the window tint is too dark, do you effectuate a traffic stop?
I do.
What happens when you effectuate a traffic stop with a reasonable inference that the window's too dark?
After explaining the reason for my stop, I test the window tint.
Can you test it at night?
Yes.
Can you test it during the day?
Yes.
If someone's window tint is legal, what do?
I let them on their way.
If the window tint is too dark, then what do?
I take further action, whether that's issuing them a warning or a citation.
Now, in this case, based on your experience, did you have a reasonable inference that this window tint was too dark?
Yes.
Once you stopped the vehicle, did you conduct the window tint test?
Objection to relevance.
It's relevant if he confirmed that it was too dark.
By that time, we're saying it's already illegal, so it doesn't matter.
Objection sustained.
Mr. De Hoyos objects to Ms. Gillette's question, arguing that the results of any post-stop window tint measurement are irrelevant to the core issue in a suppression hearing, whether Deputy Fisher had reasonable suspicion at the moment he initiated the traffic stop. Judge Hart sustained the objection. As the Supreme Court explained in Terry v. Ohio, 1968, the existence of reasonable suspicion must be evaluated based on the facts known to the officer at the time of the seizure, not on information discovered afterward. Similarly, in Florida v. JL 2000, the court held that even though an anonymous tip ultimately proved accurate, officers still lacked reasonable suspicion because they did not possess reliable, articulable facts before conducting the stop and search. The court emphasized that reasonable suspicion cannot be justified retroactively by what a search later uncovers. Applying those principles here, whether Ms. Cohen's window tint ultimately tested as illegal cannot retroactively validate Deputy Fisher's decision to initiate the stop. The Fourth Amendment requires reasonable suspicion to exist at the precise moment the stop begins. Under Kansas Statute Section 60-401, evidence is only relevant if it tends to prove a material fact at issue. Because the sole issue before the court was whether reasonable suspicion existed at the time of the stop, Judge Hart ruled that post-stop tint measurements were irrelevant and therefore inadmissible for purposes of the suppression hearing.
Now, does any officer or anyone have a test they can do on windows prior to stopping the vehicle if they have a suspicion?
Not that I know of.
Objection or relevance?
Objection sustained.
Judge, it's relevant because if there is
Objection
no,
sustained.
is there any device that you've been provided that can test a window before you have the reasonable suspicion to stop it based on your experience?
I'm going to object to that as for a legal conclusion.
No, it's asking if he has a device.
Well, the request of before you, that's the
Objection
problem.
overruled.
Do you have a device that can test window tint before the stop?
No.
Do you have to stop the vehicle to test the window?
Yes.
In this case, based on the totality of the circumstances, the technique in which you were trained and your experience, did you have a reasonable suspicion her window was too dark?
I did.
Now, once you stopped this vehicle, was there something else that drew your attention onto it more?
The window was rolled partially down.
And did you run the tag on the vehicle?
I did.
Were there any issues with the registered owner?
She had a no bond warrant out of Butler County.
Now, but your initial stop was based on the window tint.
Correct.
And which window was rolled partially down?
I'm going to object to relevance.
It's irrelevant because if the driver's side window was rolled partially down or the passenger side window was rolled partially down, if he can't tell that the other window was rolled down until he stops, that's further evidence that he couldn't see into the vehicle because he couldn't see her and he couldn't see into the vehicle.
I'm confused. Are you saying that the window
I'm
was partially?
confused also. What about the rolling down of a window makes it relevant as to the tint, percentage, darkness to the windows?
I'll withdraw the question. So Deputy, when she drove by, could you clearly see the driver?
No.
Could you see if there was a passenger?
No.
Could you see anything into the vehicle?
No.
Is that normal?
No.
I'll pass the witness.
And Mr. De Hoyos?
The only reason you,
Recross?
sorry, Judge, the only reason you stopped that vehicle is because the window tint appeared too dark as it passed you at night going 65 miles an hour. Is that right?
Correct.
Okay. You said that based upon your training, you determined it to be too dark. What is the training you've had in identifying window tint being too dark?
Just at work.
What kind of training? Like a national training like you did for your CLEs and for your law enforcement training, or was this something different?
Just my regular field training.
Okay, so in field training, they teach you how to use your eyes to determine tint values in a vehicle.
Correct.
So Kansas Law Enforcement Training Center has classes on how to identify.
Mr. DeHoyo, I just said my field training. That was not my academy training. My field training.
Okay. And the field training, who provided you the field training on how to identify how dark windows are?
I was with numerous deputies.
Okay. And are they using a national program, something that's been federally approved, or even
I
approved by
don't
any law
know.
enforcement?
I don't.
Have you ever seen any literature on any of those things?
I've already asked and answered no.
And there's no studies you've seen about how observations could be changed by the direction of travel, the way the light hits anything behind it, nothing like that.
No.
Okay.
Mr. De Hoyos questions Deputy Fisher about his claimed training and experience, focusing on the method he used to initiate the traffic stop, shining his high beams at passing vehicles at night to see inside. While courts recognize that officers may draw on their training and experience, reasonable suspicion must still be grounded in specific articulable facts, not investigative techniques rooted in speculation or guesswork. In Terry v. Ohio, the Supreme Court made clear that a detention cannot be justified by an unparticularized suspicion or a mere hunch. Instead, to satisfy the Fourth Amendment, an officer must be able to identify specific and articulable facts, which combined with reasonable inferences, objectively justify the intrusion. By questioning whether Deputy Fisher's technique was formally taught, supported by empirical evidence, or capable of producing reliable observations, Mr. De Hoyos sought to demonstrate that the stop was not based on legally sufficient reasonable suspicion, but rather on an unsupported investigative practice that falls short of constitutional standards.
Yeah, I don't have any further questions for this witness.
Any objection to the witness, Deputy Fisher, being excused from the proceedings, Ms. Gillette
No, Your Honor.
and Mr. De Hoyos.
No, that's fine, Your Honor.
Further evidence to present, Ms. Gillette,
The state will rest, Your Honor.
and evidence to present, Mr. De Hoyos.
No, Your Honor, between the deputy testifying and the exhibit, that's what we have.
Thank you. Counsel request any argument in regards to the motion.
Please,
Ms.
Your Honor.
Gillette, please
Yes,
proceed.
Your Honor, in a traffic case, in a traffic stop, officers do not have to have probable cause beyond a reasonable doubt. They have to have a reasonable inference. An inference is much, much, much lower. An officer is allowed to use their training and experience in the totality of the circumstances. A traffic stop is a Terry stop. Reasonable suspicion. Does not have to be probable cause. Doesn't have to be, I know that exact number beyond a reasonable doubt, because there's not a device that can test window tint until you stop the car. The window tint was tested, and Deputy Fisher was absolutely correct. The window tint was dark. Clearly, Deputy Fisher was absolutely right in being able to tell that the window tint was too dark. Under his totality of the circumstances, his experience, and his training under the law.
Argument for the defense, Mr. De Hoyos.
So, Your Honor, the reason I was not prepared to play that video was because I didn't expect the officer's testimony to be different from the facts shown in the video. Specifically, there were other vehicles on the road. There were vehicles in close proximity. And we don't have any kind of science studies or anything else supporting the idea that this is an unreasonable association. I think what this is akin to is bite mark evidence, which was outruled in the 70s and 80s. At the end of the day, Judge, I mean, this is a hunch, a guess, not a truth. This is, let's go see if that's too dark and pray we're right. And the idea that we do this all the time is not a defense. No, there is no science supporting this. We don't have any kind of evidence or science describing how that vehicle being behind it changes that reflect. And what if that vehicle's reflected? What if it's matte surface? We don't know, because there's no science that supports the idea that this is reasonable to go about this way. If the officer had waited to initiate the stop until after he read the license plate and came back with a warrant, I might not have an argument here. How can we tell the difference between window tint, just the circumstances of night, or if I'm holding something up? That's not illegal either. I mean, I guess my point here is I want more than a hunch to pull people over, and this doesn't beat that.
Thank you, Mr. De Hoyos. Court has had an opportunity to view the exhibit as presented today. The court has had an opportunity to listen to the testimony of the Deputy Fisher. Subsequently, the court finds the incident occurred well after sunset. There was no moonlight, there were no street lights, and there were other vehicles on the subject highway. The court finds a factual basis has been established, so this court determines the Deputy Fisher could not establish a reasonable inference or suspicion that the window tint exceeded the 35% darkness allowable by law. Therefore, the court does grant the defendant's motion to suppress.
After hearing arguments from both parties, Judge Hart concluded that Deputy Fisher lacked reasonable suspicion to initiate the traffic stop and granted the motion to suppress. In doing so, Judge Hart applied the exclusionary rule, a foundational principle of constitutional law that prohibits the prosecution from using evidence obtained through an unlawful search or seizure. Because the court found that the traffic stop itself violated the Fourth Amendment, everything that occurred after Deputy Fisher activated his emergency lights was deemed inadmissible as the direct product of that illegal seizure. In Mapp v. Ohio, 1961, the Supreme Court held that evidence obtained through a Fourth Amendment violation must be excluded from state criminal proceedings. And under Wong-Sun v. United States, 1963, not only is the directly obtained evidence suppressed, but also is any additional evidence derived from the unlawful act, commonly referred to as the fruit of the poisonous tree. Accordingly, Judge Hart's ruling meant that all statements, observations, observations and physical evidence obtained during and as a result of Deputy Fisher's stop of Ms. Cohen were excluded, leaving the state unable to rely on that evidence to prosecute the charges arising from the traffic stop.
Your Honor, the state asked the court to reconsider because you're ignoring the officer's training and experience that allows him in the totality of the circumstances and utilizing methodologies that are used commonly in law enforcement. Common methodologies are recognized. So we would ask the court to reconsider and deny this motion to suppress, the same as Judge Webster did, based on the totality of the circumstances and the training and experience of law enforcement officers, because they have a lot more experience out there in recognizing these things in split seconds than the normal layperson, which has been routinely recognized by the Supreme Court and the appellate courts, and we'd ask the court to reconsider.
As District Judge of Division 2 of the 13th Judicial District, the court overrules the state's motion to reconsider.
The state requests a stay on dismissal for a notice of appeal.
Any objection, Mr. De Hoyos?
No, I believe the state is entitled to an interlocutory appeal under the circumstances.
And the court grants the stay pursuant to the motion of the state herein.
After Judge Hart granted the motion to suppress, Ms. Gillette immediately asked the court to reconsider its ruling, essentially requesting that the judge reverse or modify his own decision. A motion to reconsideration is not a new evidentiary hearing, but a request for the court to re-examine its ruling based on the existing record, typically on the ground that the court overlooked a material fact or misapplied the law. Judge Hart denied that request and stood by his original decision, leaving the suppression order fully intact. Then Ms. Gillette asked Judge Hart to stay the proceedings, meaning to pause the case, so that the state could pursue an interlocutory appeal. An interlocutory appeal is an appeal taken before a case reaches final judgment and is used when a ruling, such as a suppression order, is so central to the prosecution that immediate appellate review is necessary. By granting the stay, Judge Hart effectively froze the case in its current posture, allowing the state to seek review from a higher court before the matter proceeded any further. On November 3, 2025, Ms. Gillette filed a notice of interlocutory appeal, and as of the time of this episode, the case remains pending. This hearing underscores just how critical the Fourth Amendment's protections are in everyday encounters between citizens and law enforcement, and how directly those protections impact the viability of criminal charges. Reasonable suspicion is not a mere technicality. It is the constitutional threshold that prevents officers from acting on instinct alone and requires that traffic stops be grounded in specific, articulable facts. When that standard is not met, courts have a duty to intervene, and the exclusionary rule exists to ensure that evidence obtained through unconstitutional police conduct is not used against defendants in criminal proceedings. Judge Hart's ruling reflects that obligation, and the state's immediate pursuit of an interlocutory appeal demonstrates just how consequential suppression decisions can be. As the case moves forward, the appellate courts will decide whether the stop that set everything in motion satisfied the minimum requirements of the Fourth Amendment. Until then, this episode serves as a reminder of why constitutional violations matter and how closely police conduct can be scrutinized inside a courtroom. Let us know if there's a case or courtroom interaction you'd like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can help foster a more informed society.